indicating that his son had told him, his therapist, and his grandmother that he had actually witnessed the murder, which makes me think that the defendant was telling, that Mr. Morton, I'm sorry, was telling the truth, and that in fact they did that, in which case they already knew that information. And there's also a discussion on the record about whether or not Eric was old enough to testify, and if either side was going to call him, whether or not a 3.5-year-old could testify. And both of us agreed on the record that would, I don't want to mischaracterize that, but it was said on the record by both the defense. I mean, the defense made a joke about it, and so clearly we all knew Eric was involved.
So if they already knew that he made statements regarding the commission of this crime, then if the defense already knew that, then those notes, that conversation with Kilpatrick would not be exculpatory?
That's why I had to repeat your question.
Yeah.
You're getting exculpatory and what's required to be turned over confused.
Okay.
And, you know, it really isn't a simple should you have turned it over question. It involves a number of facts, a professional judgment, and then a legal judgment. And I can't make that any simpler. And Mr. Scheck and I really probably have some pretty great disagreements about how to apply that law.
Judge, but why not have the 3-year-old give his testimony in camera, put that on record so that all parties are protected?
Okay, this is 2011, and we're talking about 1987. We had just begun child molesting prosecutions back in 1987, and we were desperately trying not to screw the cases up and not to make mistakes. Our track record in this county happens to be really good because we didn't do some of the things some other counties did. And we also got an awful lot of convictions on child molesters when I was district attorney. We had some pretty innovative ways that we investigated those cases. And so we didn't do in cameras. I mean, nobody thought about a 3.5-year-old testifying, period. The best of my recollection was if the child wasn't 5, they pretty much weren't testifying. And even today, probably a 3.5-year-old, I mean, it would be up to the judge, but it would involve a couple therapists and, you know, an advocacy center, and it'd be a pretty unusual move. All right, I think that's about all I can answer today. I greatly appreciate you coming out. I'm not sure I'm going to be in a position to answer questions as we move forward, but I don't know how strong I can say this, but if there's anybody who's confused about whether I'm beating myself up and about whether I'm absolutely sick about this case, you're wrong, because I am. And I'm apologizing for the system's failure, but you know, there's nothing adequate to do. You know, in their wisdom, the legislature has provided a compensation system. Before they had that, he probably wouldn't have been compensated at all. So he's free to reject that and, of course, file a civil rights suit. But the legislature actually had a pretty good plan there where they came up with the compensation program. So thank you very much.
Judge Anderson.
Did everybody get a copy of the statement? Because I do have that. If anybody didn't get a copy. Did anybody still need that?